We welcome everyone this morning to the Heritage Foundation in our Lewis Lehrman Auditorium. We would ask everyone here in-house if you'll be so kind to check that cell phones have been turned off. It will be appreciated as we begin. And of course, our internet viewers are welcome to send questions to us at any time, simply emailing speaker@heritage.org. Hosting our discussion this afternoon is Hans von Spakovsky. He serves as our Senior Legal Fellow for the Center of Legal and Judicial Studies. Mr. von Spakovsky manages Heritage's Civil Justice Reform Initiative. He also studies the legal aspects of elections, such as campaign finance, voter fraud, voter identification, as well as registration and equipment issues. Before joining us here, he served for 2 years as a member of the Federal Election Commission. Prior to that, he was counsel to the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. He is a former litigator, in-house counsel, and senior corporate officer in the insurance industry, where he worked on tort reform and civil justice issue. Please join me in welcoming my colleague. Hans?
Well, ladies and gentlemen, thank you for being here today. In 2010, President Barack Obama signed into law the Patient Protection and Affordable Care Act and the Health Care and Education Reconciliation Act, which I'm just going to call ObamaCare since it's so long. And for those of you who were in an electronic vacuum today, no, the Supreme Court did not issue a decision today. However, one of the things the law did is it mandated that health care plans must provide coverage for preventative care and screenings. And it gave the Secretary of the Department of Health and Human Services, Kathleen Sebelius, the right to determine what constitutes preventative care. She determined that preventative care includes, quote, all Food and Drug Administration approved contraceptive methods, sterilization procedures, and patient education and counseling for all women with reproductive capacity. Well, under that definition, at least 3 of the FDA-approved contraceptions use artificial means that may either prevent the implantation of a human embryo in the wall of the uterus or remove an implanted embryo from the uterine wall, thereby causing the death of the embryo, an act that constitutes an abortion in Catholic and other religious teachings. Secretary Sebelius, in what she obviously considered a magnanimous act, provided an exemption for religious employers, but only under such narrow definitions that it would not apply to a host of church-run institutions and providers, such as religious hospitals, schools, and social service providers, organizations that hire a broad range of people and provide valuable services to needy people of all faiths. To date, 23 lawsuits have been filed over this unprecedented attack on the right of religious freedom that's protected by both the First Amendment and the Religious Freedom Restoration Act of 1993. Now, to discuss this today, we have a panel of experts, and we will start by hearing from Luther Strange, who was elected in 2010 as the 49th Attorney General of my home state of Alabama. General Strange, it's an honor and a privilege to welcome you to the Heritage Foundation. He is an attorney and the founder of Strange LLC, a law firm based in Birmingham, Alabama. He was a partner at Bradley, Arent, Bolt, and Cummings, where he was the chair of the firm's Government Affairs Practice Group. He was a prominent lawyer and civic leader in Alabama even before he ran for Attorney General, and he was one of the state's leading economic development lawyers. He advised many companies on growth and expansion opportunities in Alabama. He received his undergraduate degree from Tulane, where he was a scholarship basketball player, as well as his law degree from Tulane in 1979. In the year between college and law school, General Strange worked in the Merchant Marine in the North Sea, and he's both an Eagle Scout and a Rotarian. In fact, I think he was named a Distinguished Eagle Scout by the Boy Scouts of America in 2011. And I have to tell you, General Strange, since my son just became an Eagle Scout, I hope that means that perhaps being an Attorney General is in his future.
He should aim higher than that. Definitely higher than that.
General Strange has made protecting the First Amendment right of religious freedom of the citizens of Alabama a hallmark of his stewardship as Attorney General. In fact, he spoke on this subject, I think, just a week and a half ago at a rally in Birmingham, Alabama, which is where the Eternal Word television network is headquartered, and that is a case where the state of Alabama has intervened, and he is going to speak about that to us. General Strange.
Thank you very much.
Thank you, Hans, very much, and I really appreciate your having this wonderful podium here that goes up and not just down. That's wonderful when you're 6 feet 9 inches tall. I really appreciate it. I want to introduce, before I get started, you can't maybe see from the podium here with the columns, but I have Kevin Turner with me, who's my Chief Deputy Attorney General. He is with me today, along with Andrew Brasher, who works in our solicitor's office. We have a solicitor's office in the Office of Attorney General in Alabama. Andrew clerked for one of my close friends and one of our predecessors in the Office of Attorney General, Judge Bill Pryor, who sits on the 11th Circuit Court of Appeals. So I'm glad they're here and can be with us. And I appreciate, Hans, your having us as well. This is a really important issue to me. It's an important issue to our country in this time in our history. And to be here on this panel with these great panelists is really important to me. As Hans said, the issue for discussion today is at the intersection of religious liberty and limited government. I truly do believe that our tradition of religious liberty is under attack by an administration that has really run amok, not to mention their tenure to the concerns of our citizens. To begin, let me sort of, stipulate something, and that is that the federal government has the right to regulate and even ban harmful products. That's something I think we can all agree on. Unfortunately, the Obama administration believes that it has not just the right to prevent us from buying harmful products, but also the right to force us to buy its favored products and pay for its favored services, even if those things are contrary to our deeply held religious beliefs. I'm very proud that our state of Alabama has been a leader in challenging the federal government overreach in court on many fronts, not just in health care, but we talked earlier about immigration, and there's a whole range of EPA mandates and other things that we don't have time to talk about today. As you may well know, Alabama joined 25 other states. That's an historic development to challenge the constitutionality of the individual mandate to purchase health insurance. I was personally very privileged and honored to be at the Supreme Court for the oral arguments in that case, standing as close as I am to Hans here to watch the reactions of the judges as they heard the arguments on both sides of that case. And I would be a terrible prognosticator. It'd be ridiculous to guess what's going to happen, but I truly believe, based on what I saw and based on the questions that the justices asked, that they are going to declare the individual mandate and Obamacare generally unconstitutional. Now, you can hold me wrong, guilty as charged if I am. Nobody should be crazy enough to guess that, but I really believe that that's important. And I mean, that's going to happen, and it's important that it does. Until then, of course, we're going to have to deal with the individual mandate and the other individual mandates that come out of Obamacare one by one. The one we're talking about today is the one, as Hans said, that requires all group health plans, even self-insurance health plans, to start providing coverage for sterilization and contraception in 2013. This coverage includes, as Hans said again, abortion-inducing drugs like the morning after pill and the week after pill. Although there is a narrow exemption for certain religious institutions from purchasing this product, it only applies to a very small subset of churches. There is no exception for other nonprofits, religious nonprofits, such as universities, small business owners, and individuals who object to paying for things that they truly believe violate their deeply held religious beliefs. I personally believe and agree with Hans that the mandate violates the First Amendment. It violates the Religious Freedom Restoration Act, and among other laws that we'll hopefully get a chance to talk about on the panel. I commend the Becket Fund very much for representing some of the conscientious objectors who are challenging this mandate in court. Fantastic work, and I'll talk a little bit more about our involvement in that case as well. I'm hopeful that our state will be able to join in that effort. On March 22nd, I filed a motion to intervene in that case on behalf of the state of Alabama. The lawsuit itself was filed challenging the mandate in the Northern District of Alabama, which is based in Birmingham. The lawsuit that Alabama is seeking to join, and I know that we're going to get into that here a little bit more in a second, was filed by the Eternal Word Television Network. Now, if you're Catholic, you know what the Eternal Word Television Network is, EWTN for short. It was founded in 1980 by a Catholic nun, Mother Angelica, and has since grown, and I've learned a lot more about this as I've gotten into this, to be the largest Catholic media network in the world. It also happens to be headquartered just a few miles from where I grew up, outside of Birmingham, Alabama. The management of EWTN, some folks I've come to know very well, has taken great pains to provide insurance for its 340 employees without subsidizing services, and we talked about them, abortion, contraception, sterilization, et cetera, that violate its religious mission, and it believes, and I agree with them, violates the teachings of the Catholic Church. So how did they do that? EWTN runs a tailor-made plan of self-insurance. They have Blue Cross that administers it, just so it has the greatest freedom to decide exactly what products and services it'll pay for and what products and services it will not pay for. Well, if Obamacare goes into full effect, EWTN and the rest of us citizens, most importantly, will lose our freedom to make these kind of decisions. If a business decides not to buy coverage for abortion-inducing drugs, contraception, and sterilization, it can be fined hundreds of thousands of dollars. And I can tell you almost exactly what EWTN faces in that regard. If an individual decides that she doesn't want to purchase these insurance products, then she can be fined thousands of dollars. Obviously, EWTN and organizations like it have a good reason to fight this unconscionable and unlawful mandate. But what about the state of Alabama? Let me be clear as to why I, as the Attorney General of our state, am involved in this fight. There are two overarching reasons. One, religious freedom that we've talked a lot about, and the other is federalism. I strongly believe and support the freedom of religion in this country and the right of conscience. I know that religious organizations, and I'll just talk about Alabama, feed the hungry, educate children, provide social services to those who need it the most. Take the Catholic Healthcare Network, for example. 1 in 6 U.S. patients, regardless of their faith, are treated in Catholic hospitals. In Alabama alone, the Catholic Healthcare Network operates 6 hospitals and many other healthcare services like hospice and assisted living. I was born in a Catholic hospital in Birmingham. Our 2 boys were born in Catholic hospitals, and my mother used to always tell me this story, and I'm not sure what it's apropos of, but she said, "Son, you're going to have a good time in life because you were born in a Catholic hospital by a Protestant mother from a Jewish doctor." And I've tried to figure out how that is actually worked out. But anyway, I told my wife I might tell that story. She said, "Why are you telling that story? It doesn't mean anything." But something about it. But anyway, these hospitals and other facilities employ more than 5,000 Alabamians. I believe our public policy should encourage these organizations to do the good work that they do and balance the secular and religious callings that they have. The HHS mandate will make these great Alabama nonprofits have to choose between closing down, paying a tremendous fine that I mentioned earlier, or violating their religious beliefs. That's not a very good choice of options. And the people of Alabama care strongly about the right of conscience. In 1998, our voters in our state overwhelmingly ratified an amendment to our state constitution to expressly forbid state officials from burdening a person's freedom of religion unless there is no other way to accomplish a compelling public policy. Alabama is one of only a dozen states that have actually enacted a law like that, and what makes Alabama somewhat unique is Alabama is the only state that has passed an amendment like that through a popular referendum of its voters. So that tells you where the people of Alabama are coming from on this particular issue. At the same time, there's really no compelling reason to force people who object to this mandate to provide insurance coverage for sterilization and contraception. Contraception, and this is said many times, is cheap and widely available to those who want it. So this fight is not about the right to have access to contraception. This fight is about the federal government's decision to make religious objectors pay for it. That's one of the reasons why people of all faiths are deeply concerned about this issue and are joining together to oppose this mandate. One of the fun things that I got to do, and Hans mentioned it, was just a few days ago, speak at a rally for religious freedom at Kelly Ingram Park in Birmingham. And many of you who know something about the civil rights movement in Birmingham and Alabama know that in the 1960s, Kelly Ingram Park was the staging ground for some of the largest demonstrations and boycotts of the civil rights movement in Alabama, and really, frankly, in the nation. And that made Kelly Ingram Park a particularly appropriate meeting place for this rally. The new civil rights issue of the current day has united people of all faiths and races. At this rally 10 days ago, white Southern Baptists spoke. African American pastors spoke at the rally. Catholic laity and priests spoke at the rally. And as I looked out, and you have to realize that this park is surrounded by the great monuments of the civil rights movement, I was reminded of a quote from Martin Luther King's famous letter from a Birmingham jail. He said, "Injustice anywhere is a threat to justice everywhere. Whatever affects one directly affects all indirectly." I think those quotes capture perfectly the public sentiment today about this HHS mandate. Whatever you may think about the morality of abortion-inducing drugs, I certainly hope that we can all agree that our government should not be in the business of forcing our citizens to violate their religious convictions. If the government can force someone else to violate their religious beliefs, then what will stop it from forcing you to violate yours? This HHS mandate's an injustice, and I think it's illegal. I know we'll have a chance to talk about that and take your questions. But as I see it, a federal law cannot be applied to religious objectors unless there is a compelling need to make the religious objectors comply with that mandate. There's a 2006 case called Gonzalez. The Supreme Court held that federal laws must exclude exemptions for religious objectors. And there's clearly no compelling need to make religious objectors pay for other people's abortion-inducing drugs. When I was sworn in as the Attorney General of Alabama, I swore on a Bible to uphold the Constitution of the United States, the state of Alabama, and to execute the duties of my office. Because this mandate affects the citizens of my state, the freedom of religion, I feel I have a duty to challenge it in court, and I'm proud to join with the Becket Fund and others to do that. The second reason that I'm interested in this issue is because I support limited government, and I'll tell you how the two things fit together. The freedom of Americans to produce and trade goods and services as they choose, not as according to the state federal mandates, is critical. The freedom of conscience to believe as one sees fit and to act on those beliefs is the foundation for all of our freedoms. But just as the right of conscience is our first freedom, limited government provides the space in which we can exercise that freedom. Limited government creates the government-free zone, if you will, that we need to carry our lives and make decisions based on what we believe and not what the government wants. Limited government and religious liberty go hand in hand. Now, when the federal government took over 1/6 of our country's economy and mandated that individuals and businesses buy insurance, there were bound to be some bad consequences. I think a lot of us recognize that. The contraception mandate is just a down payment on that bill. This time it's contraception, but that's not where it will end. The best way to prevent the federal government from forcing us to do things that we morally oppose is the way the founders of our Constitution intended. We need to make sure that the federal government is a government of truly limited power. The Conference of Catholic Bishops, a group I've gotten to know a little bit better in the last few months, said just the other day about our American civil society. It includes neighbors helping each other, community associations, fraternal services clubs, sports leagues, youth groups. All these Americans make their contributions to our common life, and they don't need the permission of the government to do so. That's also why states like mine have an important role to play in this debate. The states have traditionally regulated their insurance markets, consistent with their own constituents' needs and their own laws, but not anymore. After Obamacare, if the state creates a health insurance exchange, the federal government tells it what the plans on that exchange have to cover. Federal fiats like the HHS mandate threaten innovative and state efforts to reform and they interfere with the state's ability to regulate their own insurance markets according to their own laws and traditions. That's another reason why the state of Alabama has a sovereign interest in this issue. And it totally coincides with the interests of the religious groups and individuals who are concerned about the free exercise of religion. So, in conclusion, this attack on religious institutions, employers, individuals is extremely troubling to me. If the Supreme Court doesn't strike down all of Obamacare, and they missed their opportunity to do it this morning, but hopefully they will get to it in the next couple of weeks. I hope and pray and expect that our federal judges will strike down at least this HHS mandate. Until those decisions come down, our constitutional principles that we're going to discuss today hang in the balance. Will we be governed by a group of bureaucrats here in Washington who have a one-size-fits-all approach to how we handle these issues, or will we be free to govern ourselves? Is there still room for religious belief and the right of conscience, or must religious objectors comply with morally suspect laws? The stakes are high and the time is short. Either Alabamians and Americans around the country will be allowed to exercise their religious freedom to say no to something they morally oppose, or they won't. Religious liberty and limited government. Those are the issues for discussion today. I greatly appreciate the opportunity to be here. I hope you get a sense of the passion I feel about this issue, why our state of Alabama is involved, and I look forward to participating on the panel today. Thank you very much.
I think we're going to give this podium a workout between the two of us.
Put that thing down.
Excuse us for a scene change here.
That's funny.
All right, that's a little better. Well, good afternoon. It's great to have all of you with us for this important conversation. Thank you for the interest that you are giving to religious liberty, and I know there are a number of friends in the audience who are giving a major portion of their lives for the preservation of religious liberty, so I thank you in particular. All of us enjoy religious freedom, and therefore all of us should be prepared to defend religious freedom. And beginning this week on June 21st, many Americans will be doing that by observing what has been called the Fortnight for Freedom. For the 2 weeks leading up to Independence Day, events across the country will celebrate our heritage of religious freedom. The Fortnight for Freedom will also highlight how the future of religious freedom is challenged by recent policies of this administration. One of those policies, of course, is the HHS mandate we are talking about today. This policy is, of course, just the beginning of the implementation of ObamaCare, as Attorney General Strange has just outlined. We should expect many more collisions with conscience as the essential benefits that insurance plans must cover are articulated and other aspects of President Obama's health care law are spelled out. In the situation at hand, the religious exemption under the HHS mandate is wholly inadequate, and I think our panelists are going to be describing that in greater detail. But that is just the beginning of the problems. In this day and age, if religious groups need to be exempted from a policy, it's a pretty good bet that the policy is also going to cause problems for families and businesses and Americans generally. The collision with religious liberty is a good signal that government has, once again, overstepped its bounds. That's why religious congregations and ministries are called mediating institutions, buffers, protecting individual liberty against an overbearing state. And their erosion is a signal that, once again, the state is on an expansive march. Well, not surprisingly, the threats to religious liberty are growing more common as more decisions are centralized in Washington, D.C., or simply handed over to bureaucracy at any level of government, rather than left in the hand of elected officials or to citizens ourselves. Some have described this shift in power as the rise of the bureaucratic state or the rise of the administrative state, and it's been gradually increasing for most of the last century. With Obamacare, we have reached a very advanced stage of the administrative state. And what the Obamacare situation makes clear is that exemptions are not enough to protect civil society generally and religious freedom in particular from an overbearing state. In this case, to adequately protect religious freedom, we need an overhaul of the law itself. We need the repeal of Obamacare, and we need health care reform that will preserve religious liberty and respect conscience and allow all Americans to be able to find and choose health care that matches their moral convictions. Well, to discuss this further are two experts with us today, and they will in turn discuss the legal aspects of the HHS mandate cases, and secondly, the legal aspects of the Supreme Court challenge and decision that we're all expecting with regard to the individual mandate and the law as a whole. Our first speaker is Hannah Smith, who is Senior Counsel with the Becket Fund for Religious Liberty. Hannah joined the Becket Fund in 2007 following 2 clerkships at the U.S. Supreme Court for Justices Thomas and Alito. Hannah has advocated for religious liberty cases at the trial, appellate, and U.S. Supreme Court levels. She has also been featured on a wide range of media, and particularly as the Becket Fund has taken up many of these cases with regard to the HHS mandate. She lives in Dallas with her family, so we're delighted that she would be here in town to join us today in our nation's capital. Becket has been a wonderful ally as they have advanced the cause of religious liberty, not only in this situation, but in so many over the years. So we're particularly pleased to have her. And then I will also go ahead and introduce my colleague, Robert Alt, who is Director of Rule of Law Programs at the Heritage Foundation. Robert has served 2 tours of duty at Heritage, first as Deputy Congressional Liaison, and that was back in 97 to 99. And since 2008, he has been in his current role. Robert clerked for Judge Alice Batchelder on the U.S. Court of Appeals for the Sixth Circuit, and he also taught at Case Western University School of Law in Cleveland. Please join me in welcoming our 2 panelists.
Can you all hear me? Is this microphone working? Okay. It's great to be with you today. It's certainly a pleasure to be on this panel with so many distinguished guests. Since we have heard from the Alabama Attorney General today, I'm going to center my remarks on the mandate, particularly as it relates to our client EWTN in the Alabama litigation. As you've heard, EWTN is a global Catholic media network. It was founded by a cloistered nun, Mother Angelica, and it's located in Alabama. It's actually the largest Catholic media network in the world. It transmits TV programming on 8 different radio, video, and internet services, 24 hours a day, 7 days a week. And it's actually heard in more than 217 million homes in 144 countries, and that's in both English and Spanish. So it's a phenomenal asset to disseminating the religious truth, particularly from the Catholic faith. Although I have to say, my family loves watching EWTN at home, and I'm not Catholic, and we watch the animated New Testament cartoons at home because I have young children in our home. So I think it's fair to say that EWTN is a great asset to all faiths. I was asked to give a little bit of background here on the preventative services mandate itself. And then I'm going to focus the bulk of my remarks on the ANPRM, which is the current proposal that the administration has forwarded as to how we might fix this whole mess. And I'll try to explain why it's not really a fix at all. So as many of you know, and as we've heard a little bit earlier today, this preventive services mandate was a regulation promulgated by the Department of Health and Human Services under the preventive services language, which is in the ObamaCare statute. So the statute itself says we need to provide these preventive services, but then Congress delegated the authority to the Department of Health and Human Services to decide what exactly would be included in that list of preventive services. And the process for how they came up with this list is actually kind of interesting. The Department of Health and Human Services looked to an outside agency, the Institute of Medicine, and the Institute of Medicine actually convened a panel of quote-unquote experts to determine what drugs and services should be included on this list. It's been noted by many that a majority of the people that were on this panel had a very particular view of what drugs and services should be on this list because of their prior activity in pro-choice organizations. So it was this group of experts, so to speak, who came up with this list. That list was then sent back to HHS that rubber stamped it wholesale with no changes, and put that list in as an interim final rule in August of 2011 with a very narrow exemption. The exemption itself says that only churches and religious orders that are exempt from filing taxes, from paying taxes and from filing a tax return, who also, and these are all and, so there's a four-part test here to meet the exemption. So you have to be a church or a religious order that is exempt from paying taxes and filing a tax return, and has as its purpose inculcating religious values, and primarily serves people not of its faith, and, people of its faith, and that primarily employs people of its faith. So these four prongs are the exemption for the organizations that will be exempted from this regulation. So you have to primarily serve and employ people of your own faith, primarily inculcate religious values, and you have to be exempt from filing tax returns. Those are the groups, the very, very small number of churches and religious orders that will be exempted from this mandate. Leaves out in the cold hundreds and thousands of other religious organizations who are religious in their orientation but do not fall within that exemption. Religious colleges, universities, hospitals, social service organizations, homeless shelters, battered women's shelters, crisis pregnancy organizations. All of these organizations that have a religious focus are not deemed religious enough, according to the administration, to be exempted from this regulation. In January, there was an announcement by the Department of Health and Human Services that there would be no change to the exemption. There were many who were hoping that after some input from the public, after the August rule was promulgated, that input would be considered by HHS and the exemption would somehow be expanded. But in January, there was an announcement there indeed would be no change. And this set off quite a firestorm of opposition. You saw actually some quite liberal Democrat Catholics speak out very vocally in the media, disagreeing with the administration that it should have indeed expanded the exemption. And so in an attempt to remedy this situation in February, we of course saw the press conference where the president himself spoke to the nation and said that they would put forward this accommodation, this compromise that would somehow solve the religious liberty invasions because of the mandate. And it's that accommodation, that compromise that I'm going to talk mostly about today. If you believe what you hear in the media, it's a done deal. It's already been figured out. All of the details are explicit, and it solved all the problems. But I think after you've heard my remarks today, you'll realize that that is not at all the case. What the president announced at the press conference was actually just an intention. It was just a promise. It was an intention to create an additional mandate that would supposedly solve this problem, but it has not actually been finalized at all. So in March, the administration issued what's called an advance notice of proposed rulemaking. And in administrative law speak, that's sort of the first thing that you do when you're going to start a regulation. And it's a very tiny baby step towards creating this new insurance mandate, whereby the responsibility for providing these drugs and services would be shifted from the religious organization onto the insurance company. And the administration, of course, hopes that this will solve the HHS mandate debacle. The ANPRM suggests that the potential means of accommodating these non-exempt religious organizations would be solved, that these means of accommodating them would solve the religious liberty issues that have been presented by the mandate. But I'm going to show you at least two ways in which these proposed accommodations are unacceptable and why they don't solve the problem at all. The first is that the proposed accommodations leave out in the cold many religious individuals and organizations that should be protected. So there's just a whole group of religious organizations that aren't even covered by the so-called compromise. And then the second problem is that even for the religious organizations that are covered by the so-called compromise, the accommodations don't solve their core religious liberty problems, such that they would still be forced to violate their religious beliefs. So let's start with this first problem. There are a lot of people that are just frankly left out in the cold of this accommodation. So what's most important to remember is that this accommodation has not changed one bit the mandate or the exemption. The mandate and the exemption were finalized as a final administrative rule in the Federal Register the day after President Obama made his press conference. So those are final rules, and they have final legal effect. What he is saying is that he's going to promulgate a new rule, a new administrative rule that will create this insurance mandate. So you'll recall that the exemption applies only to that small subset, but this accommodation purports to apply to everyone else that did not meet the exemption under the mandate. But how does the administration define what a religious organization is in the ANPRM to be able to actually qualify for this so-called accommodation? Well, interestingly enough, it doesn't really define what a religious organization is. It suggests that the definition of religious organization should include only churches or tax-exempt organizations that are, quote, controlled by or associated with a church or a convention or association of churches, as these terms are defined by certain IRS tax code provisions. So interestingly enough, even though in the media you're hearing all of this hype that this accommodation will apply to everyone, it'll solve everyone's problems, if you actually look at what the definition is in the ANPRM for which religious organizations this is going to apply to, they haven't even settled on a definition yet. And the definitions that they're proposing are actually very limited. So under their definition of what a religious organization is that would qualify for this so-called compromise, our Alabama client, EWTN, would likely not qualify for this accommodation. It's not controlled by or associated with a church. It's owned and operated by a lay organization. So, although we've heard all this hype that the accommodation will solve everyone's problems, it's not going to solve at least EWTN's problem. And it's also not going to solve the problems of some of our other clients who are not controlled by or associated with a church or an association or convention of churches. So also under this definition, there are many others who would be left out in the cold as well. And I'll just give you a couple of examples of some religious individuals and institutions that would not be covered by this so-called compromise. A nonprofit, non-religious organization dedicated to, for example, caring for women in crisis pregnancies, not included in the accommodation. Fraternal organizations, religious colleges, or parachurch ministries that are not controlled by or associated with a church or a convention or association of churches. A religious health insurance insurer, a third-party administrator of a self-insured plan. The administration says in the ANPRM for these last two categories, a religious health insurance issuer and a third-party administrator of a self-insured plan, that they're seeking information, quote unquote, on these two issues to figure out whether or not they should be included. But as of right now, they're not covered. Also, a small business owner, because she's not a nonprofit religious organization. Even though if she's a religious person and she owns a business and she wants to run her business according to her religious convictions, she's not covered by this compromise. So all of these examples show that there are a broad swath of religious organizations that are simply not covered by this compromise, despite all of the media hype that you've heard. The second problem with this ANPRM, the so-called compromise, is that it doesn't even solve the religious liberty problems for the organizations that it purports to apply to. So let's talk about the two categories of religious nonprofit organizations that are purportedly covered by this accommodation and how they're still forced to provide these drugs and services against their religious beliefs. First, those religious organizations that have insured plans, and then second, those that have self-insured plans. So the proposed accommodation would require health insurance issuers to assume the responsibility for the provision of contraceptive coverage without cost sharing to participants and beneficiaries covered under the plan, independent of the religious organization. Okay, that's what the ANPRM says. But a few observations. Anyone who understands basic economics knows that insurance companies are not going to offer these services for free. So religious employers are still ultimately going to bear that cost, and they're going to pay for these services against their conscience through increased higher insurance premiums for their employees. And the ANPRM even acknowledges this. It even says that the money comes from premiums paid by the religious organization. So it's quite clear that the insurance company is not going to pay for this for free. And some have argued that insurance companies would cover these services for free because it helps their bottom line. But if that were the case, then they would have already been doing so. And if providing contraception really reduced the total cost to employers, as the government contends, then economic pressure itself would have already solved this problem, which, of course, it hasn't. And that's saying nothing of the expensive sterilization services that are also required under the HHS mandate. A lot of the discussion has been focused on contraception and how providing free contraception will prevent unwanted pregnancies and reduce the number of births of children. But of course, so a lot of the cost arguments are focused on that. But of course, that's not focused at all on the very expensive sterilization services that we're talking about as well, that are covered under the mandate. Okay, and so let's talk about the self-insured plans. There are many religious organizations, including our client EWTN, who are self-insured. And that means the religious organization is the insurance company. So for them, this new compromise offers them nothing. Ironically, and this is really quite interesting to me, many of these religious organizations became self-insured because some states have contraception mandates. And under the state contraception mandates, there are actually sort of de facto exemptions where if you're self-insured, you're not subject to the state contraception mandate. So many of these religious organizations have self-insured to get out of state contraception mandates. And now they find themselves, even as a self-insured entity, running into problems with the federal mandate, because the federal mandate, of course, does not have the de facto exemption for self-insured entities that these state mandates do. So the proposed accommodation would require, under a self-insured model, that the third-party administrator that runs the self-insured group health plan, they would assume the responsibility of providing these drugs and services to the employees. And the ANPRM actually lays out 4 possible ways that they could do this, that they could fund the insurance mandate for self-insured entities with third-party administrators, because of course third-party administrators don't have anything to do with the funding because the religious organization is taking care of all of that. But many people have analyzed the ANPRM and the 4 options that are laid out there. And again, I would emphasize that these 4 options for the third-party administrators with self-insured plans are not concrete. It's not like tomorrow they could just choose one of these 4 options and go implement it as an interim final rule. They're very vague. It's sort of an exercise in public brainstorming, if you will. They're not at all detailed enough that you could actually implement them tomorrow as an actual plan. And one major insurance company has already called the proposed insurance mandate unworkable and inadvisable. The Self-Insurance Institute of America has explained in its comments to HHS that none of the approaches is feasible and that several of them are actually illegal, that they would violate current laws regulating third-party administrators. So I would just focus on the fact that these ideas that have been thrown out there by the administration in the advance notice of proposed rulemaking are morally troublesome. They still require the religious organization to be involved in giving the third-party administrator or the insurance company the names of their employees, the data that it would be required. They're still facilitating this procurement of these drugs and services, which would be against their religious faith. And there are so many problems with these proposals that have been laid out by the administration. We simply don't have a proposal yet that is concrete enough that we can say that this actually would resolve the issues at hand. So we stand no closer to a remedy today than we did before the February press conference. And I just want to emphasize that our 4 lawsuits that began last fall on behalf of Belmont Abbey College, Colorado Christian University, EWTN, and Ave Maria University are moving forward. And we are at the stage now where we have responded to the government's motion to dismiss, and we'll be going into further briefing in a few months here. As of late May, there are now 23 lawsuits challenging the mandate in 14 states and the District of Columbia, representing over 55 plaintiffs. There are 3 for-profit companies that have challenged the mandate, as well as 3 non-Catholic institutions, which I think is a really important thing to remember, that this is not just a Catholic issue. This is an issue that extends to people of all faiths. There are several evangelical institutions and traditional Protestant institutions that are challenging the mandate. So we'll see next week when the Supreme Court decides the individual mandate case, whether or not we will continue with our lawsuits. Hopefully, the whole thing will be struck down altogether, and we can go home and declare victory. But even if the ObamaCare is upheld, regardless of whether or not the individual mandate is struck down, these lawsuits, I think, show the serious problems with the implementation of ObamaCare. As regulations are promulgated to implement this, there will be continuing threats, not only to individual liberty, but to religious liberty, as we've already seen. So let me just end with this final thought. This notion that the government has actually considered all of the interests and balanced them and come up with, as Secretary Sebelius said, an appropriate balance, an appropriate compromise of all the interests involved is difficult to believe. And that's difficult to believe because Secretary Sebelius herself has actually admitted under oath before 2 different congressional committees that she didn't consult the Constitution, she didn't consult relevant legal precedents, and she asked for no legal advice from the Justice Department while making her decision on the mandate. Now, that's just a breathtaking admission, if you ask me. This despite the fact that HHS received thousands of comments from religious groups around the country warning that this mandate was illegal, that it violated RFRA, that it violated the First Amendment, that it violated the Administrative Procedures Act. And notwithstanding all of those comments, the Secretary of the Department of Health and Human Services did not ask the Justice Department for a legal opinion, for a legal memo on this mandate. That is simply shocking to me. So I think Michael Gerson put it best in his op-ed in late May in the Washington Post when he wrote, "The only thing worse than indifference to religious liberty is casual, ignorant indifference to religious liberty." Thank you very much.
Well, it's my pleasure to be on this panel and an honor to be following General Strange and to be following up on Hannah's comments. And once again, I commend to your attention, if you haven't been following the Becket Fund's work on this, Hannah and her colleagues have just been doing tremendous work. I also commend to your attention, if you didn't pick one up on the way in here, a copy of my colleague John Malcolm's paper on the HHS mandate and the legal challenge to it. I think you'll find it quite enlightening. And I found it so enlightening that, in fact, I'm going to begin by stealing a quote from it. John frames his discussion with a quote from Thomas Jefferson in 1809, that no provision in our Constitution ought to be dearer to man than that which protects the rights of conscience against the enterprises of the civil authority. Not to be outdone by Jefferson, Nancy Pelosi in 2010 said, Congress has to, and I quote, pass the bill so that you can find out what's in it away from the fog of controversy. While not as high-minded or poetic as Jefferson's sentiment, Pelosi's statements did end up being prophetic. We all knew about the individual health insurance mandate in the bill, but we soon learned about the HHS mandate, the employer mandates, the general prohibitions on health insurers and employer plans from setting lifetime coverage limits, the numerous and sundry taxes that were hidden in it and are part of the Tax-Mageddon plan. And so as we started to peel back the layers of the onion, we found that the more we saw, the less there was to like. And that might indicate in some way why it is that Obamacare was wildly unpopular when it passed, and it's still wildly unpopular today. But my focus in today's comments is a relatively narrow one, and my role is a relatively modest one, so I won't hold you all too long. I'm just going to give a little bit of a thumbnail sketch of what it is that the Supreme Court is currently considering and what impact, if any, that might have on the current litigation with regard to the HHS mandate. as many of you know, the court heard oral arguments back in late March on 4 questions. But the core question before the court with regard to the constitutionality of Obamacare dealt with the individual health care mandate and asked whether Congress may force individuals whose defining characteristic is that they have not purchased a product to in fact purchase that product based upon Congress's constitutionally limited authority to regulate interstate commerce. If you haven't thought about that much, I'll let that sink in for a moment. The idea that people who are outside of commerce, whose core defining characteristic is that they haven't purchased something, should somehow be regulated by Congress under their authority to regulate interstate commerce. The very notion is unprecedented and would push, quite frankly, the contours of an already bloated jurisprudence with regard to the Commerce Clause well beyond anything that had heretofore been acknowledged by the court or attempted by Congress. So if, at this point, we're looking at a likely decision in that case, probably next week, if the court strikes down the individual insurance mandate, this would be a great victory for the Constitution and for the concept of limited government, but we need to be clear here that that doesn't necessarily mean that Obamacare is no more. Remember, Obamacare was the length of a good Russian novel. And the individual health insurance mandate constituted about 3 to 5 pages of that. So the next big question for the court is the question of severability. If, in fact, the individual mandate is unconstitutional, what do? Do they tear that 3 to 5 pages out of the book and leave the rest standing? Do they adopt the position of the Obama administration and tear out those pages and ones which they consider to be sufficiently related to them that the bill can operate? Or do they find that, as Paul Clement argued on behalf of the states challenging the bill, that in fact the mandate is so core to the operation of the bill, it's like the heart of the legislation, that if you take that out, it simply doesn't operate as Congress intended? If the court follows its black letter law precedent on this particular question, they're supposed to be moved ultimately by congressional intent. And the court has framed this in a couple of different ways. Would Congress have passed the bill, in this case, Obamacare, in the absence of the constitutionally offending provision, the mandate? And oftentimes this would be a fairly tough question. If we were looking at the tanning bed tax instead of the mandate, you might say, well, it's hard to know in the legislative log rolling, but it's a good chance it would have passed. But the mandate, in fact, was so core to the legislation. We've got multiple statements by proponents, to the extent that you look to legislative history, that suggest that, in fact, this was integral to the law, that it would seem a fairly easy case to say that it would not have passed in the absence of it, particularly if you think back to the shenanigans with regard to the passage, the consideration of the Demon Pass, the Cornhusker kickback, the Louisiana Purchase, the slim margins in both houses requisite to pass the reconciliation in order to iron out the differences. The other way that the court sometimes looks at it is whether or not the bill will operate in a manner consistent with what Congress intended if you take out the unconstitutional provision. And in that case, it's abundantly clear that this bill simply does not operate in the way that Congress intended. If you look at a piece that I co-authored with our healthcare analyst, Ed Heiselmeyer, Congress made it very clear that their goal was to achieve something on the level of universal or near universal health care. In the absence of the mandate, it is perfectly clear that there's more than a dozen provisions that will increase the cost of health care coverage and decrease the number of insured. On that basis alone, it's quite clear that Congress would not have intended to drive more people out of the health insurance market than in, and that would be the effect of an Obamacare without the mandate. So, looking at the question of at the potential permutations as applied to the current HHS litigation, if the whole law gets struck down, then the HHS mandate is no more, and Hannah gets a nice summer vacation. If the entire law is upheld, then obviously her litigation continues, and if the court strikes down just the mandate, then obviously the litigation remains. There's another, sort of set of strange possibilities of the mandate plus being struck down, whether it's the mandate plus the guarantee issue and community rating requirements, or plus, some other admixture of provisions. While it would, I suppose, be technically possible that if they start sort of picking and choosing, that they might actually hit something that could moot the litigation, I think that would be pretty improbable. And so as long as we're talking about probabilities, we should dim the lights, light the candles, I'll put on the robes and we'll see what sort of divination I can do with the tea leaves. I agree with General Strange that if you go by the oral arguments, things look relatively positive, at least for some measure of the mandate being struck down, if not more. In order to give you a little bit more than a gut, I'll give you a couple of data points in terms of how it is that folks have looked at these. The Chief Justice Roberts a number of years ago did a study on Supreme Court decisions and found that in close cases, the party that got asked the most questions at oral arguments loses 86% of the time. So on that particular notion, I'll note that on the day of oral argument with regard to the mandate, Solicitor General Verrilli, arguing in defense of the mandate, received 49 questions, which was more than Paul Clement and Mike Carbon combined. They received 19 and 22 respectively. Now, I don't know that I'd put too much stock in that, but here's something for your cocktail party this evening if you want to sort of give a reason why it is that you believe that perhaps the mandate is more likely than not to be struck down. But having said what the court is considering, I think it's good to end on a clarification again of what they're not considering. They're not considering, of course, the question with regard to the HHS mandate. It's not before the court, and they're not going to reach out and grab it. So again, if in fact they don't strike down the whole law, that issue is going to be alive and well, and Hannah's going to be well employed with regard to that for some time. But they're also not considering what is good healthcare policy, and it's useful for us to remember that as this goes along, or good religious freedom policy. And so they're looking at much more discrete questions with regard to the mandate, severability, and a couple of other issues, and that's what we should be seeing a decision on next week. So with any luck, Hannah will be enjoying a good summer vacation after next week. And with that, I will turn it back over to Jennifer for Q&A.
But before we do that, I wanted to mention one thing, and that is, I want to emphasize a point that Hannah made. I spent 4 years at the Department of Justice, and the idea that a cabinet secretary would issue a decision with such major ramifications, it doesn't matter whether you agree with it or disagree with it, but they would issue a decision like this without consulting the Department of Justice and without getting an extensive, lengthy legal memorandum written like I used to write that looked at all of the cases on this, the law, the precedent, and then used that when making a policy decision, to me shows just how cavalier the attitude was about religious freedom. I did want to ask the panel to address, we talked a lot about the First Amendment, but we didn't say a lot about the Religious Freedom Restoration Act, which is also a law that is being cited in the complaint. And I was wondering perhaps if Hannah or Luther Strange would like to comment about that federal statute and what the purpose of that was when it was passed.
Sure. I'll go ahead and take that. Many of you might recall in 1990 there was a seminal Supreme Court case that was decided, Employment Division v. Smith. And basically, Employment Division v. Smith caused a lot of upheaval in the legal world involving the standard that would be applied when religious liberty exemption cases would be decided by the court. So the standard that came out of Smith basically reversed the previous standard in those cases. And Smith basically said if you have a law that is neutral, and it's neutral towards religion. It's generally applicable, meaning that it applies to everyone. Then it will be upheld, and these claims for religious exemption from these laws would fail. Okay. So after Smith, there was just a huge response by Congress to try and change the standard back for religious liberty cases. And Congress succeeded in passing the Religious Freedom Restoration Act. Now, a little bit later, the Religious Freedom Restoration Act came up again to the Supreme Court, and they decided that it was unconstitutional as it applied to the states. So RFRA no longer applies to the states. That was a case called Bernie, for those of you who recall that. But as it applies to the federal government, RFRA is still alive and well. And the Religious Freedom Restoration Act, as it applies to the federal government in this case, prohibits the federal government from imposing a substantial burden on a religious individual or a religious institution without proving that it has done so for a compelling governmental interest, and that it has promoted that compelling governmental interest in the least restrictive means possible to the religious entity involved. So here, in this case, it's really quite clear, and we've actually had some people on the other side of the fence who are not particularly agreeable to our cause in this case actually acknowledge that the RFRA claim is very strong in our case. Here, the federal government is absolutely imposing a substantial burden on these religious objectors. First of all, it has chosen to impose this mandate that requires them to provide drugs and services that are directly contrary to their religious belief, and it does so with threat of huge financial penalties. So there's an algebraic equation that you should use to figure out the penalties based on how many employees you have, et cetera, but it's basically $2,000 per employee. So for EWTN, the first year, if they don't comply with this mandate, they have to stop offering health care, and they have to pay a fine of $600,000. And that's just the first year. And in years subsequent, it would increase over time. So these staggering financial penalties are absolutely a substantial burden under RFRA. It's absolutely a religious exercise that this religious institution should not have to provide these drugs and services against their religious conviction. Is there a compelling governmental interest? Well, there is no compelling governmental interest to provide contraception and sterilization when the Guttmacher Institute, which is a pro-choice institute, has already admitted that 9 out of 10 employer-based plans in the United States already cover contraception and these services. So it's that last 10% that the government is trying to force to provide these services, even if it means doing so against their religious beliefs. So that marginal increase in provision of these drugs and services cannot possibly be a compelling governmental interest. And the Supreme Court has said as much in a recent case just this last year, where it said that a marginal increase cannot constitute a compelling governmental interest. And furthermore, there can't possibly be a compelling governmental interest, whereas here you have a government imposing this mandate, but then exempting whole groups of people from the application of the mandate. So there are, grandfathered plans, for example. The government, I think, estimates that there are millions of plans that will be grandfathered, and they will not be subject to this mandate. So the fact that the government has said, but we want everyone to provide these services, but not this section, not grandfathered plans, and not employers that have less than 50 employees. They're all exempted, and not these other exemptions that we've built into the health care law. There are so many categorical and individualized exemptions that have been built into this law. So that shows that it's not a compelling governmental interest. And then the last point is this a least restrictive means? Absolutely not. There are so many other ways that the government could, even assuming this were a compelling governmental interest, assuming that, there are so many other ways that it could provide these drugs and services that would be less intrusive on the religious objector. The government could pay for it themselves. The government could increase funding to Title X, which is already a huge mechanism that the government uses and provides, millions and billions of dollars each year to increase family access to family planning services. So there are so many other ways that the government could provide these drugs and services that it's not the least restrictive means. So that means that under the RFRA test, this mandate is absolutely violative of federal law. And that's not even the First Amendment argument.
General Strange, did you want to say
Well, I was
anything?
just going to reiterate, Alabama has a law, a Religious Freedom Act in our Constitution that's very similar in terms of the need for a compelling interest, no other means of providing that service. So you stated it very well, very well.
All right, now we're going to take questions from the audience, and I would ask, when you ask a question, please ask a question. And if you would, please identify the institution that you're with or who you are, and please wait for the microphone because we do have an audience out in the internet watching us, so they won't be able to hear you unless you use the microphone. Yes, sir.
All right, great. Okay, is this on?
Yeah.
Hi there. My name is Mike Collins, and I'm with the Republican National Lawyers Association. Thank you all for all that great information. I was curious, with the motion to dismiss that was filed, I assume the Department of Justice had to file a brief, so I was just curious if you could speak to what exactly the administration's articulating as their defense. I guess they say it satisfies strict scrutiny and maybe some ripeness arguments, but if you could just speak to that and kind of handicap the odds going forward based on that. Thanks.
Sure. Yeah, we've received motions to dismiss by the government in all of our 4 cases, and essentially their arguments were based on standing and ripeness, and they basically said, look, you don't have a sufficient injury yet to have standing to bring these cases. These penalties don't start applying until much later, so you actually haven't been impacted directly by this mandate yet. And then they also say that it's not ripe for consideration because we are changing the rules, because we have come out with this announcement that we're creating this new insurance mandate and we're beginning the regulatory process to create that rule. And so because of the fact that we're going to change things, this case is not ripe for adjudication at this point. Essentially, our responses to that have been, look, we relied heavily on the individual mandate litigation, actually, because in the individual mandate litigation, the time period between where they filed the case and the actual imposition of the penalty was actually far longer than our case. And there's a lot of great precedent out there where courts have actually adjudicated administrative rules where the time period was much longer than in our case. So I think we had some pretty good precedent on our side that we do have standing to adjudicate this now. It's not just the fact that the penalty hasn't been imposed at this point, it's the fact that our clients have to start making decisions about their health care plans right now to be able to implement whatever policy is going to be foisted upon them. It also puts them at a serious competitive disadvantage vis-a-vis other organizations because they're not going to be able to provide health care. All of these things impact them now. So we do have standing. And then the ripeness issues are basically, look, it's always the case in the administrative area that the government could change the rules at any time. It's always the case that the government could say, well, we're going to change the rules, so therefore it's not ripe. And it's really kind of a mootness argument, actually. But the point of the matter is that, there are many precedents out there on administrative law cases where they've said, look, it's a final rule. We have a final rule here. The mandate is a final rule. The exemption's a final rule. That's ready for adjudication now. We don't have to wait for the government to figure out this new insurance mandate before we litigate this or adjudicate this case now. So those were basically our responses to the standing and the ripeness issues. All of the motions to dismiss and our responses are currently pending with the judges that are considering them, and we haven't received any judgment yet. And I wasn't surprised by that. I thought that they would probably wait until the Supreme Court decided the individual mandate cases to see if they even needed to decide our motions to dismiss or not. So.
General Strange, has the government opposed Alabama's motion to intervene?
They have, and the question that you raised is a very good one, and on the standing question for a state like Alabama, other states have filed, and on this particular issue, Nebraska's led a group of states. The question of standing was of interest to me, and as we viewed it in Alabama, EWTN and other similarly situated groups have to decide whether they're going to pay this penalty, whether they're going to do something they have a moral objection to, or whether they're just going to stop covering people. not provide insurance, in which case the state is at risk then of having to provide the Medicaid services to people who are not covered by these programs. So we think there's a clear direct interest that our state has in it. And I agree with Hannah. I think we'll wait. We won't know until after the court rules as to where we go, and the courts will pick it back up then.
Yes, sir.
General Strange, my name is Kami, but I write for the Pakistani Spectator, and my question is that, is there any possibility that any pro-life organization could have private, civilized conversation with President Obama rather than criticizing him publicly on this issue? And I'm asking this question because I live in African-American neighborhood. Most people who go to church, they are very strongly pro-life. And I'm sure that President Obama, since he has invested a lot of time in the church, his 2 children are baptized, and I'm Muslim, and I believe he is Muslim too, because contrary to some other religion, Islam run in your DNA. So, and contrary to what lot of Muslims are killing thousands of innocent people, Islamic teaching are very clear. It says if you take one innocent's life, you are taking whole humanity from the face of the earth. And I believe deep down he believes that, but we also know that most politicians would do anything to get elected or re-elected. But in his conscience, for example, if his family get pregnant, he probably wouldn't choose this option. He would rather have a baby. So I'm sure that he should apply those teachings to American public too. And regarding this, I think people were criticizing Rush Limbaugh, but maybe he chose wrong word. I mean, no taxpayer wants his dollar wasted on people who are having randomly sex, and then they want taxpayer to pay for their abortion. Thanks.
Well, if I could condense all that, maybe my response would be that I think there is a way to have a civil conversation about this issue, but and I hope that that's the way it will be conducted. In my experience, that's how it has been conducted with the groups that have exercised their First Amendment rights to protest this, and have raised the key issue. The good thing, as far as I'm concerned, because I deal with not only this issue, but a range of issues across the spectrum from, I mentioned immigration, but you can talk about the EPA, you can talk about an awful lot of areas where the federal government is simply ignoring, and that's my term, the rule of law in this country, which is the foundation of all of our freedoms. And so I think it's a debate that we're having, and I think one of the good things about this particular one, because religious freedom is so important to our country, is people are starting to pay attention now. And I think that is very, very good. And I'm glad, I appreciate again, Hans, this forum opportunity today. I think voters and ordinary citizens are just taking a look at what this means when the federal government makes a decision that, as they did last Friday, we're simply not going to enforce that law.
Hans, may I expand on
Sure.
that?
Sure, go ahead.
Point you
Oh, yeah.
made very well about the demonstration and outrage about this violation of religious liberty. It has been remarkably ecumenical, remarkably sustained, and remarkably intense ever since it began last August, actually, when the initial rumblings about this policy were put out. Many of us commented negatively at that time about the lack of protection for religious liberty in this preventive services mandate. We were very surprised in January that the president wholly disregarded them and issued the regulation as is. Even his supporters at that time were among the critics of this and standing up for religious liberty. Columnists like E.J. Dionne among them. In fact, that was what, between January 20th and February 10th, made the president stand up and have a press conference at the White House to suggest that he was changing the policy, but as Hannah mentioned, he instead finalized the policy, just as it was with its religious liberty violations. Well, since that time, the U.S. Conference of Catholic Bishops has had enormous fortitude on this and issued statement after statement. Numerous evangelical leaders for months and even as late as last week, 149, I think, organizations signed a letter critiquing the two-tier system that Hannah discussed in her remarks, the fact that religious houses of worship are getting an exemption, but if you serve those of another faith, you're not going to get that. That two-tier system is being critiqued, and on it goes. There have been 2 days that have been designated for religious liberty rallies. You spoke at the most recent of them. There were 150, I think, rallies across the country on that day. That was the second day of equal scale. So enormous attention, and then the fortnight that I mentioned. This is remarkable And that, I think, should give all Americans reason to be concerned about the future of religious liberty in America. All of us need to be articulating this to our neighbors and our co-congregants and so on, to our elected officials as well.
Can I just add, actually, the beginning of your question, you actually said, is it possible that a pro-life group could talk to President Obama in private and kind of reason with him? And I just want to focus on the fact that there were actually very intense efforts to talk with the administration last fall and do so in private. I mean, there was actually an article in the media that focused on Archbishop Dolan meeting with President Obama last fall and telling him his concerns about this. And it was done in private. I mean, he wasn't the one who leaked the story. He wanted this to be a very private sort of meeting with the president. And, then, in January and February, when the exemption wasn't expanded, the story sort of came out that, the president actually assured Archbishop Dolan last fall that everything would be to his liking, that we would take care of this, that it would be okay, and those promises were not kept. And so there was an attempt to talk to the administration in private to try and be reasonable in how we, go forward on this. And I think there was just an about face. Promises were made that were not kept. So I think that's why sort of you're seeing the intensity of the reaction the way we have, because those sort of initial attempts at meeting privately just did not work. So.
Brian?
Brian Walsh, Ethics and Public Policy Center. I actually want to follow up on what Hannah was just saying, and that is that the administration itself admits that the most aggrieved party in this mandate is the Catholic Church. And prior to the February 10th announcement of a supposed accommodation, Cardinal Dolan and others have said that there was no meeting between the administration and the U.S. Conference of Catholic Bishops. And so I know that all of you are actually tracking this issue closely. Are you aware of any attempts being made by the administration to actually bring in the religious freedom movement and find out what the issues are by the administration since the February 10th supposed accommodation? Are there any sit-downs or any negotiations that are going on so that indeed, if there is an accommodation, that the interests of the religious freedom movement are actually taken into consideration? Are any of you aware of anything like that going on?
Well, in the ANPRM, it actually says that they've been meeting with people. It says that they've been trying to meet with people. I don't know if that has actually happened, but that's what the ANPRM says, that they've actually tried to reach out and meet with people. But I'm not aware of any of those meetings.
Not to my knowledge, but I expect that if those meetings occur, it'll be after the court's decision. I think everything is sort of frozen at this point, waiting to see what the court's going to do.
Mm-hmm.
Yes, over there. Right.
Good morning. My name is
Hey.
Good morning. My name is Eric Lansing. I'm with Americans for Limited Government, and we all send our well wishes to Hannah for a very nice summer vacation. My question actually is for Hannah, and it relates to the First Amendment. ALG is taking a two-tiered approach to the religious freedom issue here. We are making an argument under the Religious Freedom Restoration Act through the administrative process. Public comments for the ANPRM are due tomorrow, so we're planning on sending that out. But we're also taking another argument, and that is that even under the Employment Division versus Smith interpretation of the First Amendment, the regulations, the mandate, still violate even the Supreme Court's interpretation of the First Amendment because it's not religiously neutral and it's not generally applicable. That's their standard. And the reason, of course, is because it applies to such a very narrow subset of religious employers, and the accommodation apparently is going to apply to a very narrow subset of religious organizations. I'm wondering what your organization's perspective is on the Smith argument under the First Amendment.
Sure. Yeah, no, I think there's a very strong First Amendment argument that we will be laying out in future briefs. But essentially, even under the Smith test, which, as I said before, is that if it's neutral and generally applicable, then that's, then the exemption will not be granted. Here, I think that the idea that this healthcare law is generally applicable just flies in the face of reason, right? I addressed this a little bit before when I was talking about the compelling governmental interest, but the idea that a healthcare law that has so many exemptions in it, so many categorical exemptions that have been granted for a variety of reasons, commercial interests, political interests, all of the grandfathered plans that are not subject to the mandate, less than 50 employees, businesses are not subject. And then also the categorical exemptions that have been offered under the healthcare law generally to healthcare sharing ministries and to what we call the Amish exemption and the Native American exemption. So there are a variety of exemptions that have been carved out from this law that I think solidify the argument that this is not a generally applicable law. And if it's not generally applicable, then you get out of the Smith test and you get back to the standard that's actually articulated in RFRA. So I think that you're right that the First Amendment argument is just as strong. I think the issue there is you just have to get out from underneath the Smith test first, whereas with RFRA, you just go straight to that higher standard, which is a little bit of a straight run, if you will. So, yeah, I agree with you.
Yes.
Matt Bowman with the Alliance Defense Fund. I'd like to engage Robert's powers of prognostication a little bit further. In your memo, you make an argument that if the court is going to strike elements of Obamacare beyond the individual mandate because they could increase premiums and thereby result in more uninsured, that the preventive care coverage requirement should be in the top tier of those. Can you expand on that a little bit, why you think that there might be reason for us to hope that even if Obamacare is only partially struck down, preventive care might be part of it?
Well, I would clarify to say that I think that it's illustrative of the general problem of taking the mandate out, whether or not I'm actually somewhat less optimistic that the court is going to get into what Justice Scalia referred to as the cruel and unusual punishment of going line by line through the bill and deciding what stays and what goes.
Or making his law clerks do it.
At least someone would have read it then, right?
But the preventive coverage provisions are illustrative of the problem. If you take Congress at its word, and I know that's a dangerous thing to do, that what it was intending to do here was to reach, universal or near universal coverage, then if you take a look at something like the preventive coverage provisions and the requirements that are added to that, those are going to necessarily drive up the premium costs for insurance. Well, at that point, you can actually just go to the CBO index and see that for each % increase in cost, how many individuals you will have drop off the insurance rolls if you don't have an insurance mandate requiring them to purchase it. And so throughout the paper, we outline a number of provisions that will necessarily drive up premiums and reduce the number of insured. But in general, the mandate really is sort of core to the bill in terms of how it operates. The Obama administration itself in the court has argued that the requirements the insurance companies provide coverage for individuals with pre-existing conditions at roughly the same rates that it provides to everyone else simply won't work and will lead to the failure of the health insurance market in the United States unless that is pulled out with the mandate. And essentially what we point out is there's no real logical limiting principle to stop there other than that, well, there's probably two reasons. One, I think it was perhaps a quasi-political move on the part of the administration to sort of try and force the court's hand to say, if you're going to take out the mandate, then you have to take out what was seen as the nicest goodie in the bill as well. And so we're going to make you be the bad guys. So that was one. And two was just to try and find some sort of a bright line. But the further you get into the bill, the more you find that there are tons of other provisions that, quite frankly, do not operate as Congress intended them in the absence of the individual mandate. So I guess my one clarification would be I think it's illustrative of the problem. I don't necessarily know that they're going to go in with an X-Acto knife and start cutting out individual provisions that don't operate properly. My guess is you're probably going to get one of three approaches. It all stands, it all goes, or four approaches. They strike down the mandate or the mandate plus the requirements with regard to pre-existing conditions. But I doubt they're going to go and start slicing much thinner than
Robert,
that.
what about the lack of a severability clause?
Well, there's what the court says and there's what the court does. So first of all, generally speaking, the courts read in severability clauses, and at this point, the standard essentially is unless there's clear intention on the face from Congress that they intended it not to be severable, oftentimes expressed through a non-severability clause. So that would be one potential way that they could have done it. But if you take a look in recent years, quite frankly, the court has bent over backwards to preserve as much of a statute as possible, notwithstanding its standard that it's supposed to go ahead if the law won't operate as Congress intended in the absence of the offending provision. It's supposed to strike the whole thing down. Yet if you take a look, for instance, at the honest services fraud cases, where they essentially rewrote the statute, despite the fact that that as written, it was void for vagueness and basically incoherent. So that said, I think in this particular case, leaving aside the question of whether there's a severability clause or not, this really is kind of a unique case in a number of ways. One, this really does present the court with a question with regard to the mandate that goes beyond anything that the court has permitted Congress to do in the past. So this really is sort of stopping Congress from taking a step yet further. But it's also, I think, unique with regard to the severability question, because here you have such a massive bill, and it's rare that you would have something so core to the operation of the bill be what's challenged. And so in this case, I think that's really going to be guiding the court's interpretation.
Where Robert's legal analysis ends is where, of course, the policy question reopens, and that means this is something that Congress is going to have to treat no matter what the court decision is. Should the court leave the law intact, Congress will need to repeal Obamacare for religious liberty and our other liberties to be protected. Should it strike down the individual mandate but not the rest of the mess we've been talking about today, Congress will need to go the rest of the way and repeal the rest of the law before taking a second step, which is, of course, setting a path towards healthcare policy for America that respects the free market, respects individual liberty, respects religious liberty, and allows Americans to be able to choose from a wide variety of health plans, a plan that will meet their family's needs at an affordable cost and according to their conscience. And so there's a major policy conversation that will be renewed once this court decision comes down.
Do we have time for, I'm sorry, go ahead.
I'm going to jump in with just one footnote, and that is Jennifer raises a good point. The problem of having folks who have more of a litigation mindset on the panel is that we sometimes forget about the appropriate role of the other branches, and that is, of course, Congress and the executive, but should not be let off the hook on either the question with regard to Obamacare in general or the HHS mandate. Obviously, should the courts not go the right way, but even before the courts issue their decision in your pending litigation, Congress should be stepping up to the plate to defend religious liberty and to defend the proper contours of limited government in the Constitution.
Okay, well, we got time for one more question. Yes, sir.
My name is Lyle Jackson, and I'm just a terrified taxpayer. My question is the legislation so broad that the Secretary of Health and Human Services gets to make a definitional statement about what is a religious organization and what is not a religious organization? I mean, I can understand that she's got to promulgate rules that say, here's what we're going to do with health care, but does the legislation empower her to make that simple decision about this is a religious organization and this one is not? And it looks to me like that's what she's doing.
I'll make a broad policy comment, and I expect that Hannah or others may want to make a precise legal statement. This is what I was getting at with regard to the administrative state. The administrative state invades civil society in every avenue, whether it be healthcare, education, or any number of other fields. And has all kinds of ways that it touches our lives and all kinds of words and categories that it uses that must be defined in every instance under thousands, in this case 2,700 pages of this law. That is what I mean about the machinery of the administrative state beginning to crush civil society in general and religious liberty in particular. So we should be concerned about definitions at every turn of the federal government in exactly the way you've talked about.
You know, that's such a good question, because the authority delegated to HHS was, of course, to define what preventive services means, right? And so when they came up with the list and made it an interim final rule, the mere fact that they included an exemption was an admission by the government that there were religious liberty issues here that were very significant and that needed to be addressed. So the mere fact that they acknowledged that and created an exemption is, I think, significant, because it shows that they understood, even though they didn't ask the Department of Justice for a legal memo, they understood that there were religious liberty issues involved here. And then, of course, when they created the exemption, the definition that they drew of what is religious and what is not religious, of course, gets them into all sorts of hot water. But the authority that they were given was to define preventive services. And the admission that they needed an exemption is, I think, on their part, significant to the fact that there are serious religious liberty issues here.
I'd want to take one more chance for you that didn't pick up the paper, pick up our great new paper on this issue by John Malcolm, who's our newest lawyer at the legal department. And I want to end with this thought, and that is, there's been a lot of coverage of the HHS mandate, but one thing I haven't seen really talked about is what I really think is the pernicious effect of the narrow exemption they came up. And what do I mean by that? Well, look, you know, it doesn't matter what the religious institution is, you know, whether it's Catholic, evangelical, Jewish, Muslim, those churches and religious institutions provide a huge amount of the charitable services that we have throughout our country and in our society, everything from homeless shelters to schools to other things. And those religious institutions operate those charitable services without asking what the religious faith is of the people that they serve. But under this narrow exemption, if a Catholic institution is running a homeless shelter and they want to be able to obtain this exemption, that means that when people show up who need help at their homeless shelter, they're going to have to ask them whether they are Catholics. And if they are not Catholics, they have to reject them and they can't help them. Not only that, but someone who wants to work in one of these charitable organizations, like a homeless shelter, if the Catholic institution hires them and they are not Catholic, they will lose the exemption. So that is an absolutely pernicious effect of this exemption if it stands. So please give me a round of applause to thank our speakers today.